Good afternoon. We'll begin today in prayer, and it's my pleasure to introduce Father Bob Dowd, the president of the University of Notre Dame.
Well, thank you, Professor Muñoz, and welcome everybody. It's great to see you all. It's wonderful to be together to welcome Justice Barrett back to campus for today's conversation. But as we gather here on this beautiful day, we can't help but think about the violence that we've witnessed in this country in recent weeks. We can't help but think about the shootings at Annunciation School and Parish in Minneapolis. We can't help but think about the shootings at Evergreen High School in Colorado. And of course, we can't help but think about the assassination of Charlie Kirk yesterday at Utah Valley University. We're all shocked and dismayed by this terrible violence, and it's good for us as members of the Notre Dame community to come together and rededicate ourselves to respectful dialogue across differences, and to rededicate ourselves to being peacemakers and peace builders. We pride ourselves here at Notre Dame in taking the challenges of our world seriously and doing everything we can to make the world more humane and just. That is in the DNA of Notre Dame, and that is because of our Catholic mission. So as we gather here before today's conversation with Justice Barrett, let's just take a moment to pray. Loving God, we thank you for the many blessings in our lives, and we thank you for gathering us together today. We pray for our country and our world at this time. We pray for an end to all violence. We pray that we might do our best to take the challenges of our world seriously and be agents of hope in our world today. Help us to do our best to promote respectful dialogue across differences. Help us to treat each and every person we encounter as a child of God. Help us to respect the inherent dignity of all people. Help us all to grow in understanding and in wisdom, in compassion and in courage, and in faith, hope, and love. We make this prayer through the intercession of Our Lady and in the name of Christ the Lord. Amen. Thank you very much. I'm going to turn it back over to Professor Muñoz.
For all those who are able to stand in a sign of unity and our love of our country, will you join me in saying the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. I'm Phillip Muñoz. I'm the director of the Center for Citizenship and Constitutional Government. Thank you so much for being here. I want to begin by thanking our leadership, Father Dowd, Provost McGreevy, especially Notre Dame security, Justice Barrett's security team. Given what happened on Wednesday at Utah Valley University, this event today had to happen. Wednesday was an attack on all of us who believe in argument, in debate, in free speech, in the clash of ideas. Mr. Kirk was killed on a university campus, assassinated for making arguments, assassinated for engaging in the very work a university is supposed to do. We pray for his soul, for his wife, for his children. And we move forward with resolve to continue our work of hosting spirited debates, of teaching the principles of American constitutionalism, in encouraging students, as he did, to think for themselves by presenting them arguments from all sides. We had to host this event today because our democracy, our ability to govern ourselves as Americans, that will perish if violence silences us. So thank you for being here. Today's event is also particularly meaningful to me on account of whom it's named for. My conversation with Justice Barrett today is our 2025 Jeannie Poole O'Shaughnessy Memorial Lecture. Mrs. O'Shaughnessy was a member of the Notre Dame class of 1986. She was a cheerleader when she was here as a student. She loved America. She loved Notre Dame. 4 years ago, almost to the day, she passed away suddenly and unexpectedly and tragically. And so this event is named in her memory. Patrick, her husband, is here, as are her Notre Dame friends and family. Notre Dame is a great university. It's also a family. And we do things somewhat differently here. And so today we had a private mass for Jeannie and the family. And Patrick, we're so happy you come back, and you remain in our prayers as your whole family, and of course, Jeannie. All right, my notes say I'm supposed to talk about the center now. Let me just say this. The Center for Citizenship and Constitutional Government exists to do events like today. We host events, we teach undergraduates about the Constitution, we train PhD students to go be faculty. We have spirited debates. We do all the things you do at a university. So I encourage you to learn more about us. Visit us on our website at constudies.nd.edu. We have some phenomenal events later on this semester. Let me just leave it at that today. I hope you'll join us in what we do if you find what we do of interest. Okay, let me tell you about the format for today. I'm going to sit down in conversation with Justice Barrett about our new book, Listening to the Law. I believe there are copies of the book available in the lobby. I have not shared any of my questions with Justice Barrett. She doesn't know what she's in for. And I'm going to try to save some time for you to ask questions. Now, we want to do this in the most practical way possible. So we're using a technology. It's called Slido. There's a code, 331-2187. This is a way you can enter in your questions on your phone, right? If you can do that now, that would be great. You can also vote on the questions you want me to ask. Identify yourself. If you're affiliated with Notre Dame, let us know your affiliation. You can vote on the questions. I'll get the questions through technology, and then I'll ask them. You can also see all the questions that are there. Justice Barrett obviously has not seen any of these questions too. As always, per our tradition, we'll start with student questions. Now I ask you, because of security, they don't want you playing with your phones during the talk. If you're on your phone, please keep it discreet and low in your lap. No pictures at all. Please don't hold your phone up. Security will take that very seriously. I don't need to say this here, but consistent with Notre Dame's policies, no disruptions will be tolerated. Okay, we have another tradition here at the center. We invite our undergraduate students, one of our fellows, our Tocqueville fellows, to introduce our speaker. So I'm going to introduce Kathleen Farnan. Kathleen is a senior from Pittsburgh, a constitutional studies minor, and she will introduce Justice Barrett.
The Honorable Amy Coney Barrett serves as Associate Justice of the Supreme Court of the United States. Originally from New Orleans, Louisiana, Justice Barrett received her JD from Notre Dame Law School in 1997 and began her legal career by serving as a law clerk for Judge Lawrence Silberman of the U.S. Court of Appeals for the D.C. Circuit, as well as for Supreme Court Justice Antonin Scalia. After her clerkships, she spent 2 years in private law practice in Washington, D.C., before joining the faculty of Notre Dame Law School in 2002. In 2017, she was appointed a judge of the United States Court of Appeals for the Seventh Circuit. 3 years later, President Trump nominated her as an Associate Justice of the Supreme Court, and she took her seat on October 27, 2020. Please join me in welcoming Justice Barrett back to Notre Dame.
Welcome home.
It's good to be home.
Yeah. I don't want this to be a heavy event, but I think we have to start with Utah. What would you say to the country, including college students, about the state of our country in light of all the recent political violence?
I think it's important, and I think that both Professor Muñoz and Father Bob highlighted this a moment ago, that we learn to have disagreements in a civil and collegial way, and Notre Dame that is, as Father Bob said, in the DNA here. I think that too often when I look around the country, political violence is the most grotesque symptom of it, but there are others too, just in online conversations and the way that people treat those with whom they disagree. And that's actually one of the points that I try to make in the book, is that's just not a way to run a society. And I think that you at Notre Dame, and especially you students, can model a different way to be.
Do you worry about your own safety? Do you give up your freedom to be a Supreme Court justice?
Yes, you do give up your freedom, more than I realized when I said yes to this. I'm in very good hands, so I feel safe, but we do have round-the-clock security, and so I don't have the same freedom of movement. I wanted to go running around the lakes today, but wasn't allowed to do that.
Did you know that was going to be the case when you... Take us back to the moment you realized that you were going to get the nomination. Was that an immediate yes? Did you hesitate to say yes to the nomination, and did you understand what you were getting yourself into?
I did hesitate to say yes. I actually didn't fully appreciate the loss of freedom points until after I was already in it, and it was too late to back out. But I did hesitate to say yes, because it was a radical life change. I was on the Seventh Circuit at the time, so I had left my tenured position on the faculty, but I still had my office in the law school. I was still around the law school frequently. We lived in Harder Heights, just a few blocks from campus. We had a wonderful community here, wonderful friends, and it was hard to imagine both giving all of this up, moving our family to Washington, but also living life in the public eye. And frankly, some of the things that Professor Muñoz was just asking about, the bitterness of public disagreements, what I knew that I would face in the confirmation process, and then if I were confirmed, what I would face as a justice, having the thick skin and the stomach to endure that. I knew that would be a lot, and I knew that it was asking a lot of Jesse, my husband, and our family.
If you could, you're not going to like this question. If you could go back, would you say yes again?
So one thing that Jesse said that has become a mantra in our family that I've really held on to is, and some in the audience I'm sure have heard me say this before, is when we were deciding, we were pacing, in our house just a few blocks away from here. I remember us pacing back and forth in the bedroom talking about it, whether I was going to say yes to the interview, because you can't say yes to an interview like that unless you would be willing to say yes to the nomination if offered. And Jesse said, I'm in, but on one condition: if we do it, we have to burn the boats. No looking back. no second guessing. The confirmation process could get very difficult. I think we've all seen how confirmation processes can go. It could be very difficult if you get confirmed, and we've had our share of threats and protests and all of that sort of thing, and we couldn't anticipate exactly what any of it would look like at the time. But Jesse was absolutely right that it's just not sustainable to second guess the choices you would make. So I haven't thought about it. I burned the boats.
Okay. Would you ever leave the court for another job?
Professor Muñoz, I gave up the tuition benefit, so.
One more follow-up. How would you reform the confirmation process?
The confirmation process, part of the difficulty is when you're actually sitting there in the hearing room, but a lot of the difficulty came from just the public chatter, the way that news was covered, or the way that interest groups, tried to attack. There's just a lot of character assassination involved. And so, again, I think this circles back to the conversation that we began with, which is, I just think that it's not just the confirmation process, that's just one symptom of the poisonous discourse that we've got going on in America.
Okay, let's change our focus. How's it being back at Notre Dame?
It's so great.
Yeah, do you miss
yes,
us? Yeah.
I do miss being here very much. In fact, we were doing some other travel before this for the book, and I just kept thinking, oh, once I get through this trip, once I get through this talk, then I'll be home. But really, I'm not going home to DC until Sunday, but this is also home for us.
Yeah. Did you have a favorite place on campus?
Favorite place on campus? Well, like I said, I loved running around the lakes, and I'm sure everybody would say the grotto.
Yeah. Chapter 1 of the book is titled My Life in the Law. Your life involves a lot of juggling. 7 kids, several still at home. Jesse has his own professional career, a very successful one. I don't know if any woman in American history with kids at home has had so much civic responsibility as you. How do you do it all?
Well, I don't know if it's true that no other woman in America has had as much civic responsibility with young kids, but I couldn't do the jobs that I do without my husband, who is very much not only an equal partner, but he is, at this season of our life, contributing even more to running the home front than I am. When I was in South Bend, the commute was short, and I could get back and forth to campus or to my kids' schools very quickly, but now Jesse works from home, and I've got a long commute, so he really juggles a lot, and I think we've got a lot of good support. And we have to be very, very disciplined about our time. And I'm sure that my kids would appreciate it if I give a shout out to how easy they all are.
What's your advice to, we were just talking with Kathleen. She's thinking of law school next year. She's enormously talented, enormously ambitious. Are Notre Dame women who have professional ambitions, but also think they might have a vocation to be a mother? What advice do you have for them?
I think I would say you need to discern at every stage what you're called to do. And Jesse and I have certainly done that. And before Jesse, I didn't know Jesse when I decided to come to law school, or even when I accepted my clerkships, which were my first jobs out of law school. But I would say for both the women and the men who want families and careers, that not only should you approach that very thoughtfully and consciously, but you always, and I always have, and I was just telling some of Professor Muñoz's students this earlier this afternoon, I've always placed my family first. And so I always had a posture that I would be willing to walk away from a career if it was not the best thing for my children for me to keep working. And Jesse has felt the same way. And so I think always prioritizing family, regardless, or being willing to make career shifts, is important, because you can pursue both things, but the family piece is always the most important.
Chapter 2, you write about the judicial role, and let me quote you. You say, as Thomas Paine put it, in America, the law is king. We justices don't dispense justice solely as we see it. Instead, we're constrained by law adopted through the democratic process. The nomination and confirmation of federal judges, including Supreme Court justices, should be seen through this lens. What do you mean that justices don't dispense justice as you see it?
I mean that my assessment, one thing, the analogy I use in the book is King Solomon. And I think when people think of justice, they often think of someone like King Solomon, who sees the women fighting over whose baby it is, and he says, fine, he comes up with the solution, I'll split the baby, knowing that the real mother wouldn't allow that to happen. Judges don't, when I say that we don't dispense justice as we see it, I don't just look at a situation and then figure out what I think the fairest result would be, like Solomon, drawing from my own wisdom or my own sense of justice. As a federal judge, my role is far more constrained. It's constrained by the separation of powers in the Constitution. And so my job is to apply the law that has been democratically adopted by the people, and sometimes actually that might run counter to what I think might be the most fair result.
Is it difficult to sign on to an opinion or to write an opinion where you think the result is unjust?
Yes, and I think it can depend, the degree of difficulty depends on the nature of the case, but it can be. You really have to learn to put aside your personal preferences and follow the law where it leads.
Do you ever pay attention to arguments that are more political or consequential in nature? So the recent case on affirmative action, students for fair admissions. One of the more powerful arguments, at least in my opinion, was, look, if the justices strike down the use of race in admissions, it's going to make it harder for minorities, certain minorities, to gain admission to places like University of Notre Dame. Do those types of arguments, which really aren't legal in character but more political, or the results, do they have any purchase on the justices?
I guess I'll just speak for myself. They don't have purchase on me because I do think that, as I described before, I agree with you that as a political matter, that is an important argument. But I think as a judge, really what you're doing is applying the law, and you're not responding to those kinds of arguments. Those kinds of arguments really belong to the political arena, and Students for Fair Admissions is a constitutional decision, so it's not something, if the legislature wanted to respond to those arguments, it couldn't adopt a legislative fix or a legislative form of affirmative action, but if the people want to respond to those arguments, they could amend the Constitution.
When you get those arguments, in oral arguments or in a brief, you just dispense with them? Do you even pay attention to them?
Well, those arguments were made in the case.
Yeah,
those arguments were made in the case, but again, there are arguments, think about in the context of free speech. There are certainly arguments that that are true and that would have purchase on us as people, that certain kinds of speech are very hurtful to people. The famous case of the Nazis in Skokie, marching in Skokie, which was a Jewish community. Some speech is very, very hurtful, but that doesn't mean that we put aside the First Amendment because of the political arguments about certain kinds of discomfort or disruption that would flow from permitting free speech.
Okay. Chapter 3 is titled Working Together. I think you know where I'm going to go with this.
I don't know, actually.
I'm going to ask you about your majority opinion in Trump v. Casa. It's a recent case involving birthright citizenship. You called the...
No. Yeah. It didn't involve birthright citizenship. Those of you who know the case know that I'm not actually really correcting him.
It was a complicated case.
Yes.
You called the dissenting opinion extreme.
Yes.
You wrote that its argument was, and I'm quoting here, at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself. Not exactly friendly. You write a lot about the friendship on the court. Tell us about the friendship on the court and those opinions that are a little less than friendly.
My opinion wasn't friendly to the ideas. But it wasn't an attack on Justice Jackson personally. Justice Jackson had written a solo dissent, and that portion of the opinion, which I should hasten to add, though I drafted it, was the opinion of the court. I always dislike calling a majority opinion just my opinion, since I'm speaking in that capacity on behalf of the institution. So sometimes, and it was true in the Casa case, justices can get, the arguments can be heated. I'm not heated just for the sake of doing it. It's not my personality or style, but in that particular case, I made the judgment, and the court, everyone, who was on the opinion, agreed with that judgment that that was warranted or calibrated to the strength of the arguments made or the force with which the arguments were made in the dissent. But I like Justice Jackson very much, and Justice Scalia's mantra is mine. He used to say, I attack ideas, I don't attack people, and if you can't distinguish between the two, you got to get a different day job because you don't belong in a multi-member court. I mean, we have life tenure, so I think it is much like an arranged marriage with no option for divorce. You don't pick your colleagues, but you will be working with them for the long haul, and so that's just the stick reason, right? To if you've got the carrot and the stick, that is reason to be disciplined about getting along. But then the carrot is just that it's wonderful and warm to have good relationships with people that you see a lot of. So we have lunches together. We have lunch every time we have oral arguments. So we have arguments and conferences 2 weeks of every month. So that's 4 days a week during those 2 weeks. We have lunch together, and you cannot discuss cases. You can't discuss work. So we get to know one another because you're talking about your kids, what you're reading, what you're doing, current events, those kinds of things. It's a lot harder to dislike people or to treat them badly when you know them. And kind of, I guess this can be a theme throughout, going back to our opening theme. You can much more easily debate heatedly with people when you know not to take it personally because you are personally warm to them, when you actually have relationships with them.
Yeah. Can you tell us, one of the book is wonderful.
Oh, thank you.
Tell us you write about the traditions and the tradition of the newest member of the court, the most recent appointee, giving a welcome dinner for the recent addition. Tell us about that.
Yes, the court has many, many traditions. The lunch tradition I just described is one. Another, which Professor Muñoz is referencing, is that the formerly most junior justice, so once you're number 8, which I am now, gives a welcome dinner for the new number 9. So I gave the welcome dinner for Justice Jackson, and when you do that, you find out what do they really like. I tried to find out her favorite foods and what entertainment she would like. She loves Broadway, so I found someone who is a Broadway singer to sing selections from the musical Hamilton because she really loves Hamilton. So we had a wonderful evening, and it's just the justices and their spouses, so it's not a big welcome party for even anyone on the court outside of just the small circle, and it's an opportunity for the court to welcome in and get to know the newest member.
Let me move to your chapter on judicial power. And you title that chapter Judicial Power and Judicial Restraint. You give equal billing to judicial restraint. Why?
Because I think restraint is the flip side of power. If you have power without restraint, I mean, who wants anyone, any branch of government or any person to have power without any restraint? And I think that people who want the court to exercise more power and people who fear it's exercising too much power, I think both camps of people forget about the restraint part, that the court can neither exercise as much power as some may want or as others may fear.
Okay. You write a bit about Dobbs. This is in the third part of your book called Thinking About the Law. You discuss your judicial philosophy. You're an originalist. I think maybe everyone here knows, but tell us in your understanding, what's the core of originalism?
So the core of originalism is an approach to constitutional interpretation, which says that the text of the Constitution is the law. And to understand what the text of the Constitution means, much like to understand what any text means, what it communicates, one must understand what it meant to those who lived at the time it was ratified. So it's an approach to constitutional interpretation that tries to interpret the Constitution consistent with its original public meaning.
Okay. I'm going to come back to originalism, but let me ask you just 2 questions about Dobbs. Given that you're an originalist, Dobbs overturned Roe versus Wade, Planned Parenthood versus Casey. No one really tried to defend Roe, even its defenders, on originalist grounds. Given that you're an originalist, was that a relatively easy decision for you?
So The methodology that underlies Dobbs is somewhat complicated because of precedent. So even Dobbs itself Dobbs was not written as a purely originalist decision because even as an originalist, no judge in the country and no justice either can interpret things on a blank slate. So Dobbs did overturn Roe, but in doing so, it said that Roe was inconsistent with the other precedent that interprets the relevant clause of the Constitution, which is the Due Process Clause of the 14th Amendment. And the way that that clause has been interpreted is not itself originalist in the sense that the question was not simply did those who ratified the 14th Amendment think that it protected a right to an abortion.
Dobbs was the case that involved the leak. I know you want to answer this, but I want to ask. Do the justices know who leaked?
Hope springs eternal. You're going to ask? So there was an investigation and a report, and the report that the court released said that we did a thorough investigation, but we were not able to identify the person consistent with the applicable standard of proof.
Do you think that will happen again?
A leak?
Yeah.
I certainly hope not. I think one reason why I wrote the book is I want people to have confidence in the court as an institution. And I think one thing that the leak represented was tearing down the institution. And I think, and for the students in the room, for you, as you go out into the world, be institution builders. And I hope the leak was a low point. I hope that the leak was we've tightened up our security, so hopefully, it would be difficult for it to happen. But I think also, I hope at least that the leak and its aftermath have inspired the court and the court family, as we call ourselves on the inside, a commitment to, we really need to be careful to guard the institution, qua institution.
Did the leak destroy trust? Did it change the culture at all? Did it really harm the court as an institution? And relatedly, when you have lots of new personnel every year because all the clerks are new, how do you address the leak with the new clerks?
Justice Scalia used to have a very stern talk with new clerks, and he would say, if you ever leak information now or any point in your lifetime about what happened in this court, I will hunt you down and destroy your career. Jokingly, but only partly jokingly. And I don't say that to my clerks, but I have a very stern talk with them about the importance of confidentiality. And I don't hire people who I have any concern about their judgment, discretion, or integrity in the sense that they would leak a draft of an opinion to a reporter. But all of us could use reminders about not letting details slip to our spouses or our parents or carelessly letting notes or things like that sit around. And all of us could use reminders about how obligations of confidentiality extend beyond just the moment.
Can we talk a little bit about Justice Scalia?
Sure.
One of the most charming things in the book, I thought, is you talk about walking into the chambers and going left, not right, because the clerks go left, and you were used to being a clerk. Do you think of him often? Do you feel closer to him now that you are a justice?
I wouldn't say that I feel closer to him now that I'm a justice, but I do think of him often. I think about how he would, that the problems that I am confronting are different from the problems that Justice Scalia confronted when he was on the court, simply because the issues of the day are different. The court's docket is a reliable, Justice Potter Stewart called it a reliable mirror of the domestic issues that are plaguing the country, and our current issues are different from those that Justice Scalia confronted. And so sometimes, I think about him, even though our fundamental jurisprudential approach is the same, I wonder how he would be responding to some of the challenges and difficulties that I face. And I do think of him often, and sometimes I think, man, I wish I could write as well as he did.
Yeah. I want to go back to originalism. Was Justice Scalia especially influential on you developing your judicial philosophy?
So I entered the clerkship as an originalist. In law school, in reading cases and studying cases, I came to that conclusion myself as a young lawyer. But certainly, clerking for Justice Scalia matured my philosophy, made me more committed to it, and it allowed me to see it in action. It allowed me to see how one could actually implement what is to a student simply an academic exercise.
I'm going to sound like a professor here. What do you think?
You are one, that's okay.
Yeah, okay. What do you think is the best argument against originalism, and why is that wrong?
I think the best argument against originalism is that the history can be very difficult to discern, and that the history doesn't have all the answers. And I actually think both of those things are true, but I think that any alternative, well, I think several things, and I'll try not to be a professor and go on too long about it. But I think that the history is difficult to discern, but any other metric that one uses for constitutional interpretation also involves difficulties. Yes, the history does not always provide the answer, and it isn't always clear. It can be difficult. Same is true for every other constitutional methodology. But finally, and most importantly, if you believe, as I do, that the constitutional text is the law, and if you think that the words that comprise the law are understood as they were understood by those who ratified it, then it doesn't really matter if it's hard. It is the task of the judge.
Okay. So even in its weak points, every approach is going to have weak points.
Every approach is going to have weak points. If you asked me what the weaker points were of more pragmatic approaches, I could, rattle off those. I could say a lot about those.
Okay, let's hear it. What are the weaker points about a more pragmatic approach?
A more pragmatic approach would say, well, I'm going to look at this and I'm going to see what I think is sensible. Well, I think that gives an awful lot of discretion to a judge. I mean, does everybody in the room, I don't know, maybe since we're at Notre Dame you'd say yes, but does everybody want me just deciding what's sensible? I think that that's not the role of the judge in a democratic society, for judges to decide what they think the best result is, because that might differ. Judges have a very narrow perspective. We come from a narrow slice of life. Justice Scalia used to say, when it comes to that kind of a judgment, to the 9 of us up here, I mean, I'd rather leave it to like the 9 people that you've randomly picked in the Kansas City phone book. Why would these 9, elite lawyers in Washington be the ones to just make those sensible judgments?
Can I ask about precedent?
Yes.
Do you have a philosophy of when to overturn precedent? And let me connect it to the originalism. If you think a precedent is wrong on originalist grounds, when does the originalism trump the precedents, and when does precedents trump the originalism?
So that is one of the difficult questions for an originalist, because if the text is the law, you were asking me about affirmative action earlier. If Congress enacts a law that is inconsistent with the Equal Protection Clause, for example, by requiring affirmative action, let's imagine, Congress can't do that. Congress can't trump the Constitution. So then the question is, well, why can judicial precedent trump the Constitution, and how could the court ever choose to follow a decision that's inconsistent with the text of the Constitution itself? And my answer to that, and this is something that I thought about and wrote about as a law professor, most of the time that question doesn't come up, because in most cases the court lets sleeping dogs lie. So the question, when precedent is very, very well settled, and that's the kind of precedent that would be most disruptive to overrule if there was a head-on collision between a judicial decision and the text, those kinds of cases don't get challenged because there is such wide agreement that we should just let that sleeping dog lie. So some law professors say, that in fact paper money is unconstitutional, that the legal tender cases which interpreted the Constitution's gold clause are wrongly decided. Well, that doesn't really matter. I think you can all rest assured that that question is not coming to the court anytime soon. So even if it's true that those decisions and that paper money is unconstitutional, we would all let that sleeping dog lie. So I don't think that as a practical matter, that problem really poses a serious challenge to originalism in practice.
Is it just a matter of prudential judgment then? Is there a clear method that you can point to I hear a lot of prudence.
What do you mean, a clear method?
Well, you let sleeping dogs lie. But when do you know they're fully sleeping?
Well, the court has discretionary jurisdiction, so I should back up to say, in order for a case, the court, unlike Congress or the president, we don't have an agenda. So we don't come in and say, this is what we're going to accomplish this year, or the first 100 days of this term, this is what we're going to do. We are a reactive institution. So we take the cases as they come to us, which all federal courts have to do, but then our jurisdiction has a separate element of discretion. So litigants come to us, we get about 4,000 petitions a year. Litigants ask us to take cases, but then we exercise our discretion to decide which cases are those that warrant the court's intervention. And we take between 55 and 60 of those cases. So that is where some discretion comes in. When I'm saying there's not often a head-on collision, if you're not asked the question, so if we don't agree to answer the question, then we don't face that head-on collision.
The book is, it's not a scholarly book. It's not meant for scholars. It's meant for citizens. Tell us why you wrote it.
I wrote the book because I wanted people like all of you. Some of you are undergraduate students. Some of you are lawyers, many of you are not, and I wanted those who don't know the court to get to know it. The court is in the news a lot, and I said before that I think institution building and confidence in institutions is important. And I love the court, and I love the Constitution, and I want to share it with people. I want to invite people in. And I think it's easier to have confidence in institutions when you understand them and you know what happens in them.
You write about the Constitutional Convention, the amendment process. What would you have universities do? So the book is a book in civic education. What would you have us do to better civically educate?
Well, you probably do a lot to civically educate your students, Professor Muñoz.
Try?
Yeah. I think that the University of Notre Dame probably does an excellent job in educating its students and offering classes for those students who desire to take them, which would acquaint them with those ideas. But I mean, I think the public lectures, and I'm not being self-serving just saying this one, but I know that your center does a lot of programming, as do others, that give people the opportunity to engage and to hear, even if they're not a political science major, how government works.
Yeah. All right, I'm going to boot up my computer and we'll go get some questions for the audience. I have a few more for you at the end.
This is the highest tech Q&A that I have ever participated in, and I've done a lot of Q&As.
Let's hope it works. Okay, this is the one that's got the most votes. From Noah Dolan, class of 29. Have you ever made a ruling at any point in your career that you regret?
Burn the boats.
Michael Kennedy, class of 26. How would you respond to conservatives who are frustrated with originalism, who aren't opposed to a looser interpretation of the Constitution in order to get results?
I would say, if you want different results, turn to the democratic process. Turn to your legislatures, your state legislatures, and Congress. If you want to change the Constitution, I describe in the book how the 27th Amendment was actually ratified because of the work of a college student from the University of Texas. So if you want results, you turn to your fellow citizens for results. For courts, we're about applying the law.
Okay. This is from Father Henry Steffen, who's a PhD student. A PhD student who should be writing his dissertation right now. Notre Dame Law School, he says, at Notre Dame Law School, we talk about educating a different kind of lawyer. Does being a graduate of the nation's best Catholic law school make you a different kind of Supreme Court justice?
Oh, that's a great question, Father Henry. I think it doesn't make me a different kind of Supreme Court justice insofar as I don't approach the job or decide cases differently by virtue of the fact that I went to Notre Dame. But Notre Dame has made me a different kind of person, and therefore I think about my contributions to the law, to society, thinking about my job as a form of public service. I think all of those things Notre Dame has shaped who I am, and I hope that Notre Dame and its mission and my own Catholic faith shape how I treat other people and have helped my integrity.
I'm going to to skip down. This is from Mackenzie. She says, I'm a Notre Dame alum, lawyer, and I'm expecting my third child.
Congratulations.
I just took a step back from my career for my kids. As a mom to many and at the height of your profession, what is your advice to young women who want both a career and to be open to life?
I think, as I said in the beginning, I think you should always, if you want children, I'll tell a story. When our son John Peter, who's adopted from Haiti, we had been in the process of adoption for a long time. It looked like that adoption wasn't going to happen, and then it came back online very suddenly, and it was able to happen after the earthquake in Haiti. And I was a full-time law professor at the time. We had a very busy house already, and I found out that I was pregnant on the same day that we got the call asking us if we were still open to having John Peter. And it was January in South Bend. You can imagine the weather. I threw on my big, heavy, long coat, and I walked from our house in Harder Heights up to Cedar Grove, and I sat on a bench, and I thought, okay, life might be hard, but at least it's short. And, and the most important thing I could do, like looking at the gravestones, I thought the most important legacy I can leave is my children. And so, of course, there was never any doubt that we were going to say yes, we wanted to take John Peter home, but it just helped me, it helped my outlook. And I think that both moms and dads should think that way about building their families and their career, and the children should not take the backseat to career advancement. I also think that it's fine to step back and then jump back in later, and I know very many women who have done that, who have taken a pause when children are younger and then return to work. And I think that now it's a much friendlier world for that.
Okay. This is from Connor Farrell, class of 28. Do you ever find it challenging to separate your own moral views from the objective view of the case? Do you find your moral views influencing your decisions?
That is one of the challenges for a judge, is to put those moral views aside. I can honestly say no. I can honestly say that I have disciplined myself and I work very hard to set those aside. In the book, I use the death penalty as an example. It's a situation in which, I am Catholic and I accept the church's teaching about the death penalty, but I sit on death penalty cases and I don't allow my views about the death penalty to affect what I think the law requires. And if I did think that it was immoral for me to sit on a case, or if I did think that I wasn't going to be able to separate my moral views, I would recuse from the case rather than impose my own moral views on the law.
Okay. Can you please talk about the process for deciding emergency motions, aka the shadow docket, which seem to be much more prevalent in recent times?
So I was interviewed about the book last night by the professor who coined the phrase shadow docket, and I convinced him to switch gears. No, I'm just teasing. He recognized when, at the time he wrote shadow docket, it was more in the shadows because it was less known, but it's certainly out in the open and gets a lot of attention now. So the emergency docket, I said before that we get about 4,000 petitions for certiorari a year and we take about 60 cases. The emergency docket, these applications come up on an entirely different track. So these cases are litigation, they involve litigation that's still ongoing in the lower courts. So we're not reviewing final decisions and we're not giving final answers. These are cases that come up in an interim posture, and essentially what happens, because many of them have involved the administration, I'll just use that as the example. Let's say the lower court, a district court, has enjoined an administration policy, and the case is still going to be litigated, but while the case is litigated and while the court and then the Court of Appeals is deciding how the case should be finally resolved, that policy is on hold. The administration in several recent cases has come to the court and will say, we would like this injunction to be stayed so that we're not prevented from pursuing this policy in the interim while the case is being litigated. We accept that at the end of the day, if the policy is illegal, that will be enjoined. But in this interim period, because litigation can take a long time, we think we should be free to pursue the policy. It doesn't turn just on the view of the merits, and we don't do the full vetting on the merits that we do for cases on the regular docket. So we just ask ourselves, is it likely that they will succeed? Is it likely the applicant? And I'm using the administration because that's what's been in the news, but they're not the only ones who come by any stretch with emergency applications. And then we engage in other kinds of questions like, well, are they really going to suffer irreparable harm if they don't get it? What are the equities? So it's a 4-factor test, but the important take-home point is that it is not the final judgment of the court.
This is from Haley Garrett, class of 26. Do you think Catholic politicians and government leaders, I assume she means Catholic government leaders, are targeted more than other religious leaders in conversations about the separation of church and state?
I don't know the answer to that question. I don't think I could make a relative comparison, but I certainly, my off-the-cuff reaction is that I think many people are, that it's not just Catholics that are in the public eye on that.
Maybe 3 or 4 generations ago, maybe less now.
Yeah, I think.
William Hunter, graduate class of 24 and a master's student 26. Is there a possibility that the court's decision announcements will be streamed, published in the way that oral arguments are now? Would this help build trust in the institution?
Well, that's interesting. I don't know that it would help build trust in the institution, particularly because nothing is said in the announcements that's not available in the opinion itself. The announcements are actually a relic of days when the opinions weren't released to the public or when the public had a difficult time getting access to them. And so they're really a traditional feature of the court, and I think they're if you're ever in Washington, I encourage you to go for an opinion hand-down day. I think it's a civic education. It's a neat experience for those in the courtroom to hear. But nothing is said that's not publicly available, posted on the court's website and on the internet, the second the opinion is released.
Okay, this is from Mike Mora, class of 26. Why must the executive submit to the judiciary if he believes, or she, has the proper constitutional interpretation and that the judiciary is wrong? In short, would you affirm judicial departmentalism or judicial supremacy?
So that is one of the ongoing and very old debates in constitutional law. And by old, I don't mean stale. I just mean has been with us, since the beginning. And many different presidents have very strongly asserted departmentalism. Andrew Jackson, Abraham Lincoln being just 2 examples. And it's certainly true that each branch of government, each government officer in both the state and the federal governments takes an oath to uphold the Constitution. And I don't think that that's a question that will ever be firmly resolved. If it's been ongoing for more than 2 centuries, I think that debate will continue.
This is from James Brennis. What are your thoughts about lifetime appointment for good behavior for the Supreme Court?
I'm in favor.
From Lindsay Trematera, Notre Dame Law School, class of 2022, MBA, class of 24. In the state of today's political climate, how do we learn to be more accepting of other people's different points of views? Have intellectual and respectful discourse, uplift one another?
Okay, so this sounds trite, but I think from the very beginning, it's just be kind. I think a lot of debates are begun, from the very start of a conversation, people have an edge. So I think a lot can be, and this is just very practical advice, but I think a lot is body language and tone, and people are disarmed and they melt a little bit more if you're interested in them and you invite them to share their ideas in a way that's not hostile or doesn't put them on edge. And again, I think that the Notre Dame community and Notre Dame students can model that. And then I think you don't push back. Think about that, I attack ideas, I don't attack people. You can have a spirited debate without tearing somebody down.
Can I mention something from class? I've noticed in recent years, on the first day of class, I tell the students, look, you can disagree with each other. It doesn't mean it doesn't mean you dislike someone if you disagree with them.
Right.
And it's almost like we've forgotten that. It's the arguments, and you're trying things out. It's not the person.
Right.
And give each other some more space.
Give each other space, and I think a little humility on both sides helps too.
Okay, my students prepared a lightning round of questions.
Oh my gosh.
Yeah. So these are from the students. I take no responsibility for these.
Oh, okay, well that's easy. Easy for you to say.
It is, yeah. All-time Supreme Court justice you most admire.
Oh gosh, Justice Scalia.
Okay. Favorite movie?
So my daughter Tess is in the audience and she'll laugh. Our family vacation favorite is Meet the Parents.
What is your go-to karaoke song?
I don't have one.
If you had a go-to karaoke song,
There's a reason that I don't have a go-to karaoke song.
do your justice robes have pockets?
I have 2 sets of robes, one does, one doesn't.
Do you think Hesburgh Library is beautiful?
I like Touchdown Jesus. I won't comment on the inside.
What are you reading now that is not related to your work?
I just finished a book called The Woman Who Smashed Codes, about a woman who developed the field of cryptology, and I have not started a new one just yet.
This is from a law student for sure. When sifting through the hundreds of extraordinary clerkship applications you receive, what are the 3 things that make an applicant stand out?
Well, does somebody want to come up to the stage for a live interview? I don't sift them. I have a committee sift them, but when they come to me to interview, the 3 things that make them stand out are integrity and being articulate and being able to debate and listen to ideas with my law clerks.
What's the best advice you've ever received?
Oh. So I've received a lot of good advice, but because it's on the tip of my tongue, I'll just share something I say in the book is advice that my dad gave me, which I think of often. Control your emotions or they will control you.
Okay. This is our last one. We'll conclude it after this. Don't mess this one up. Final score of tomorrow's Notre Dame Texas A&M.
I'm not going to jinx it.
Ladies and gentlemen, please join me in thanking Justice Barrett.
Thank you, Barrett.